On True Crime Today, the courtroom drama intensifies as Vallow Daybell, the so-called Doomsday Mom, challenges her extradition while facing conspiracy charges in Arizona. And the story of Diddy keeps getting darker as we learn more about his childhood and the alleged sex parties that were held at his home by his own mother. And in Wisconsin, Morgan Geyser, one of the perpetrators of the infamous Slender Man stabbing, sparks outrage with her release after nearly 7 years in confinement. And later, we'll discuss the possibility of parole for Yolanda Salvador, the woman who murdered Tejano superstar Selena nearly 30 years ago now, with retired FBI Special Agent. Thanks for joining us. Today we begin with Vallow Daybell, the courtroom buzzing the other week with tension as she, Vallow Daybell, the woman once dubbed the Doomsday Mom, made her first appearance in Maricopa County Superior Court, convicted in Idaho for the murders of her 2 children, 7-year-old Joshua J.J. Vallow and 16-year-old Tylee Ryan. She now faces new charges in Arizona, charges just as chilling as her past. This time, she took center stage not just as the accused, but as her own defense attorney. We'll take a look at some clips in just a moment. Spinning a web of legal jargon and eyebrow-raising motions. It's just as bad as you thought it would be. Vallow Daybell's twisted saga is a tragic cocktail of apocalyptic delusions and calculated actions. Alongside her 5th husband, Chad Daybell, she subscribed to a belief system so outlandish it could kind of be mistaken for a plot of a bad sci-fi movie. Except it wouldn't be believable. But this is all too real. Their vision of imminent doomsday involved labeling people as zombies whose spirits had supposedly departed. In this macabre fantasy, the prosecution asserts it fueled the murders of her children and Chad's first wife, Tammy Daybell. But her recent proceedings weren't about her dark past. They were about her new legal battle in Arizona, facing conspiracy to commit murder charges for the death of her 4th husband, Charles Vallow, and the attempted murder of her niece's ex-husband, Brandon Boudreaux. Vallow Daybell was ready to fight. Her strategy? Kind of that throw everything at the wall and see what sticks, but I think she thinks she actually has a strategy. She questioned everything, including the state's decision to extradite her. The police investigation and the intent of the prosecution, it just doesn't make sense, she whined, with her trademark defiance, as the courtroom collectively braced for another one of her spirals into legal theatrics. Let's take a look.
So the state has claimed in their response that these documents are not material in the case, and this defense is entitled to this specific evidence for the proposition that this evidence can be used to impeach the thoroughness and good faith of the police investigation and the intent of the prosecution. That's Kyles versus Whitley, 514 U.S. The acid test of this prosecution is not a matter of determining if the defendant is guilty of the crimes that the defendant is charged, but rather, was any crime even committed? And where is this evidence? This defense has yet to find any evidence of a conspiracy in the 100,939 pages that have been turned over by the state. The state does not get to say, like they did in their last motion to us, in their last answer, to say, oh, we gave you over 100,000 pages, so that ought to keep you busy. That's not how it works. These are serious charges, and these are serious consequences for these charges. In determining the actuality of a crime, the state is required to meet, in reality, not in theory, a standard of culpability that is defined by law as a crime. The state is required to meet the challenge of defense reasonably without bias, conflict, prejudice, or speculation. So the defense, we keep filing motions for discovery since we don't know if it's some kind of strategy of the state that they're holding back this actual evidence of conspiracy in hopes that the defendant won't have time to prepare a proper defense against the evidence that comes forward at the last minute. This court has denied every motion the defense has filed to acquire this evidence. The state has claimed in their response to the defense's motion that the defense's request is overbroad and wide-sweeping. Is this the defense left to pinpoint where this evidence is and try to find it? No, that is not the law. The state is required by law to give the defense evidence of the crime they are being charged with. This is the purpose of the Brady Law and the right to due process. This is why in 2020, the United States enacted the Due Process Protection Act that provides defendants like me with greater protection, Brady versus Maryland. The state has continued to impede the defense from conducting a defense. This is a violation of the 14th Amendment of our great Constitution and the defense's due process rights. Today, the defense is requesting that this court do the following three things. One, order the state to turn over all evidence of a conspiracy since our trial begins in 76 days from today. I would also ask that they would pare down their witness list to these witnesses that will actually be testifying so the defense can conduct productive interviews. And then I would like for all motions and responses to be sent directly to the defendant in a timely manner. I'm having a really hard time getting this stuff. I don't get it from ILS to 7 days after things have been filed, after your orders have been rendered. I'm not getting these. This defense intends on starting trial on time without delay, and I request that also that this defense requests that the court grant the motion to order the state to produce all discovery of extradition at this time so that we can get started on getting prepared for trial.
Just as bad as predicted. Here was Vallow Daybell. By the way, she only wants to be called Lori Daybell now. She's standing by her man, who already has been convicted of murdering her own flesh and blood. Now lecturing the court on her constitutional rights and legal procedure, as if she just passed the bar last week. Judge Justin Bursky clearly unimpressed.
What does anything in the extradition have to do with the underlying charges? Can you tell me that?
Yeah, it's to find out why all this started when I can't find any evidence that there is. So
have you read the grand jury transcripts?
I have.
Okay, the grand jury transcripts summarize what the state's evidence they intend to produce at trial.
I understand that.
So when you say you can't find anything, that is the summary in the grand jury transcripts.
Correct.
Okay. So I guess I don't understand how an extradition a year or so after the fact, after the indictments, would have anything to do with the underlying charges. So can you articulate that for me?
The prosecution, for their part, wasted no time dismissing her claims. The evidence presented at trial will pertain solely to the dates leading up to the indictment. The deputy county attorney calmly explained, effectively dismantling her attempt to turn the hearing into a circus act. Yet, despite the firm rebuttal, Vallow Daybell forged ahead, as she always does, clutching at any thread that could prolong her defense. She doubled down, citing obscure legal precedents and demanding access to more than 100,000 pages of evidence, a feat that would overwhelm even the most seasoned legal teams. According to her, the prosecution's failure to deliver the smoking gun she believed existed was a violation of her constitutional rights. Serious charges require serious evidence, she proclaimed, her resolve still quite unshaken.
I can, Your Honor. There's the detectives that are on these cases are all continuing to go back and forth with all of these different agencies. You have the FBI, you have all the different agencies that are working together. You have Rexburg, Fremont County, you have Chandler and Gilbert. You have all these people. Then I have them coming up, and they're going to be on the stand, and they're going to be in trial, and they're going to be saying what they reviewed. They've reviewed all these things, and there's communications between all of these agencies that I feel like that the defense is privy to. We should be able to have that and look at that and see where all this came from, where all this started, why they waited 2 years to make these charges. There's all these things, and why they decided to extradite when I saw someone sent me a news article 3 days before I got brought to Arizona that MCAO was putting out a release that they were not going to pick me up and they were not going to extradite me to Arizona until after my appeals were finished. So it's contradictory to that. I just don't know where it came from, and there's a lot of things that are mystery questions to the defense that we are entitled to according to the law.
All right, well, everything you've just told me, none of that would be relevant in the trial in the case in chief. Does the state intend on producing any iota of evidence or presenting any scintilla of evidence of anything that happened after the dates of crime that have been charged in the indictments?
Leonard, the state, although there is information that occurred after that will relate to the conspiracy that has been disclosed to the defense, anything that occurred after the indictment, during the extradition process, is completely irrelevant and will not be brought in during the trial.
I didn't mean the date of crime listed in the indictment. I meant the date of the indictment. Correct. So the state doesn't plan on presenting any evidence to a jury of anything after the indictment.
Correct.
So how would that, anything to do with the extradition, be relevant to your trial then?
I feel like it's relevant to the whole, Your Honor, in the sense that the police investigation and the intent of the prosecution, it doesn't make sense. I would like to be able to have that.
This is why we don't let crazy people go to trial. I think we need to adjust the bar a little bit here in terms of sanity and allowing someone to represent themselves in court. I don't think she meets the bar, but the state says she does, so Circus continues. Despite her theatrical performance, Judge Bursky held firm. He declined to rule on her motions immediately, instead setting deadlines for the prosecution's responses. The trial, he reminded everyone, was still on schedule to begin March 31st of 2025, with a final trial management conference on March 18th. There would be no delays, no deviations, no matter how many motions Vallow Daybell filed. Moving on now, Sean Diddy Combs. His story, staggering highs and now earth-shattering lows. It's taken another grim turn. Once celebrated as a music mogul, he now stands accused of federal sex trafficking and racketeering charges, with nearly 40 civil lawsuits swirling around him like a storm. And if that's not enough to make you sit up and take notice, a new Peacock documentary, Diddy, The Making of a Bad Boy, drops some serious bombshells about his early years. Let's just say what happened in the house of his mother might explain a lot about what's happening now. Tim Dog Patterson, a childhood friend of Diddy, paints a haunting picture of their formative years in Mount Vernon, New York. Weekends in the Combs household? Oh, they were anything but ordinary. Wild parties allegedly thrown by Janice Combs, Diddy's mother, filled the air with reefer smoke, the clink of liquor bottles, and the soundtrack of adult behavior no kid should be privy to. Patterson's voice, raw in the documentary, lays it bare. It would be a thing to mistakenly walk into one of the bedrooms and see a couple in there butt naked. Yeah, that's the kind of environment young Sean Combs grew up in. Now, this isn't just a trip down memory lane for shock value. The documentary suggests that these early exposures, what Patterson calls desensitizing, may have laid the groundwork for the man Diddy became. And this brings us right to the allegations. Federal charges of sex trafficking, racketeering, and transporting individuals for prostitution. If convicted, Diddy's looking at 15 years to life behind bars. His legal team, of course, denies everything, saying Mr. Combs has never sexually assaulted or sex trafficked anyone, man or woman, adult or minor. But these civil lawsuits, they tell a bit of a different story. Let's talk about the documentary for a moment, because it's not pulling any punches. The trailer alone feels like a punch to the gut. Childhood photos fade into chaotic party scenes, while friends and industry insiders drop bombshell after bombshell. Take a look.
Sean Combs is a monster.
I want to speak about this now because I've witnessed everything.
I think Sean Combs can get away with anything.
I've known Sean since he was 4 years old. That's my little bro.
He already knew what he wanted.
I can be your manager, just give me a chance.
I went to a lot of puffy parties. These were the parties that you needed exclusive access to get into.
He thought that if people fear him, they respect him.
Honestly, I didn't want to be around him unless there was cameras.
Nobody's shooting me. Nobody's shooting me. Nobody's shooting me.
When Puff was around, it was like, uh-oh.
Get it together or this could be over.
You got me acting crazy in front of all these people.
Something is not right with this.
I've been with Sean for quite a while, and I've captured a lot of moments. Anytime the studio or any rooms is red, it's making love and sex. Some of the ones who went in the room, for sure, they were underage.
They said they could ship me off and sell me to anyone.
How did this superstar music mogul become an alleged monster?
And I can show you how we have fun and stay out of jail, too.
Back to Patterson. He believes those weekend parties at Janice's house were kind of a training ground, though not the kind anyone wants, saying, quote, "I've always been asked the question why," Patterson says, "but I truly believe it all goes back to childhood." And while Janice Combs might have shielded young Sean from the brutal details of his father's murder, the environment she created was far from idyllic. Diddy's childhood wasn't just about parties, though. He was the altar boy who played Little League and made the football team at his Catholic high school. But according to Patterson, his peers could smell he was not tough. And the bullying, it came hard and fast. Meanwhile, at home, there was no shortage of larger-than-life characters, pimps, pushers, and hustlers. The allegations continue, mingling with family friends. DJ Easy Lee Davis, another Mount Vernon native, confirms the rumors. She made sure everybody was comfortable in ways that sound more like a fever dream than a family gathering. All allegations. And then there's Diddy himself offering a glimpse into his early sexual experiences. In a 1999 Vibe interview, he describes losing his virginity at 12, imitating rough movies he'd seen in adult films. "I was acting, just like porn stars act," he admitted, as if recounting a scene from someone else's life. But this isn't just about what happened then, it's about what's happening now. The civil lawsuits detail decades of alleged abuse and manipulation. And then there's the band star, Sarah Rivers, who breaks her silence in the documentary, recounting unsettling experiences with Diddy during the filming of Making the Band. Her tears, her words, they add another layer to this disturbing story. Moving on now, Slender Man, Morgan Geyser, one of the teenage perpetrators of the infamous 2014 Slender Man stabbing, and now been granted release from the Winnebago Mental Health Institute after nearly 7 years of confinement. The decision made by Judge Michael Bourne comes despite the horrific nature of her crime and the enduring trauma of her victim, Payton Leutner. Let's take a look at what happened in court.
Now, while it is this examiner's opinion to a reasonable degree of professional certainty that facts weigh in favor of Ms. Geyser's petition and placement on conditional release at this juncture, I also recognize considerations which may give pause. The issue of Ms. Geyser's diagnosis enigma is one such consideration. Ms. Geyser now reports that she's never experienced auditory hallucinations or psychotic symptoms otherwise. The etiology of her historic psychotic symptoms remains unclear, especially in light of the fact that she has not been prescribed antipsychotic medication in recent years and has nevertheless not evidently demonstrated a reoccurrence of psychotic symptoms. She warrants ongoing close clinical monitoring and treatment in part to support her transition to the community through, as importantly, to effectively and efficiently determine and respond in the event of any reoccurrence of symptoms of a major mental illness. I read that paragraph in full because that's an important consideration, and it caused the court pause with regard to how to evaluate circumstances. However, when I read the entire report by Dr. Collins and Dr. Lundell, as well as what they testified to, I'm satisfied that those are caveats for the court to be concerned with and to evaluate in a way with regard to the issue of dangerousness It's not necessarily a veto over the release on a supervised release petition. That the court's going to grant the release, I'm satisfied that by clear and convincing evidence that under the current set of circumstances, Ms. Geyser does not pose a significant risk of bodily harm to herself or others, or of serious property damage.
Yeah, what could possibly go wrong? For those unfamiliar, Geyser and her accomplice, Anissa Weir, lured their friend Payton into the woods under the guise of a fun outing. The girls had been obsessively reading online stories about Slender Man, a fictional supernatural entity said to stalk and abduct children, convinced that committing murder would prove their loyalty to this mythical figure and grant them safe passage to his supposed mansion. They devised a plan to kill Payton. On May 31st of 2014, the three girls ventured into a park in Waukesha, Wisconsin, where Geyser and Weir enacted their twisted scheme. After playing for a while, they coaxed Payton deeper into the woods. There, in a chilling act of premeditated violence, Geyser pinned Payton down and stabbed her 19 times with a kitchen knife. The attack targeted critical areas, including her arms, legs, and torso, with one wound nearly missing her heart. Believing their victim was either dead or close to dying, the two attackers fled the scene, leaving Payton alone in the dirt. Despite her life-threatening injuries, Payton found the strength to crawl to a nearby path, where she was discovered by a passing bicyclist who immediately called for help. Her survival was nothing short of miraculous. Geyser and Weir they were apprehended at that time later that day, walking along a highway. When questioned by police, they showed little remorse. Their focus instead on the bizarre belief that Slender Man was real and would harm their families if they didn't carry out the attack. During the trial, Geyser's attorney cited her diagnosis of early-onset schizophrenia as a major factor in her delusions. However, mental illness does not erase the sheer brutality of her actions or the calculated nature of the attack. Now, Geyser's release has sparked outrage and concern in Wisconsin, while her lawyers and 3 psychologists claim she has made significant progress. In managing her schizophrenia, this decision raises serious questions about justice and public safety. Let's not sugarcoat it. Morgan Geyser didn't just make a bad decision as a kid. She meticulously planned an attack to take a life, all to satisfy the delusions of a monster she read about online. Some people are just broken. The release plan involves Geyser transitioning to a group home for 60 days, where she'll be monitored by the Wisconsin Department of Health and Services. Let's be real here. Does a group home and some supervision truly compensate for the magnitude of her crime? Payton Leutner will carry the physical and emotional scars of that attack for the rest of her life. Well, Geyser now gets a chance to reintegrate into society. Geyser's co-defendant, Anissa Weir, was released under similar conditions in 2021. The parallels between their cases have reignited debates about the balance between mental health, rehabilitation, and accountability. Both girls were diagnosed with severe mental illnesses, and while that's a factor to consider, it should never overshadow the brutality of their actions. The legal journey leading to Geyser's release has been long and controversial. This isn't the first time she's petitioned for freedom. Earlier requests were denied, including one as recently as April of 2024. So what changed? According to experts, Geyser no longer poses a danger to herself or others. I've heard that one before, and then suddenly there's a danger to themselves and others when they're released. But who am I? But are we willing to gamble public safety on their clinical assessments? Let's not forget about Payton. While Geyser's life moves forward, Payton's has forever been altered. She's chosen to live a private life away from the media spotlight, but that doesn't mean her pain has disappeared. Imagine being reminded daily of the betrayal and the trauma, and now knowing your attacker is free to walk with us, amongst us. The public reaction to Geyser's release has been mixed, to say the least. Some argue that her mental illness absolves her of full accountability and praise her progress. Others, however, see this as a gross miscarriage of justice, an insult to Payton and her family. So how do you reconcile the desire for rehabilitation with the need for justice? What if there is no such thing as rehabilitation for some people? We have a hard time accepting that in our society. Can both coexist without compromising safety? The most unsettling part of the story is the lingering uncertainty. What measures are in place to ensure Geyser's reintegration doesn't pose a risk to others? How can we trust a system that's already allowed one perpetrator back into society? And more importantly, what does this say to other victims of violent crime? For now, Geyser remains under state supervision until she's 53. That's a cold comfort for those who believe her release is a dangerous misstep. In cases like these, the line between justice and rehabilitation blurs, leaving us to wonder, has the system truly served its purpose, or has it failed Payton Leutner once again? Now, moving on to Selena. Yes, that's Selena, the Tejano music star who had her life taken away back in 1995 by Yolanda Salvador. Joining me to discuss the possibility of parole for Yolanda, now 30 years later, is retired FBI Special Agent and Chief of the Counterintelligence Behavioral Analysis Program, Robin Dreek. Robin, what do you think about this? All these years later, is it right to see a possibility of parole for Yolanda Salvador?
Well, legally, yeah, I see the possibility here because of our system. I'm going to throw my personal opinion in here. I don't think someone like this should be allowed to be paroled. I mean, you took a life, you did it violently, without remorse. The defense that she had, as I reread it up again, was bogus. I mean, but most importantly, we got to do, and it hasn't come out yet, victim statements.
Yeah.
It's really, to me, these things are always up to the family. Legal system, yes. Family needs to weigh in on this, and those affected, because, too often they are ignored, I think. And I think the family really needs to be the ones that are the go, no go on this. Mm-hmm. And if she's eligible because of our system, that's one thing. But if the family says she shouldn't be let out, then that's what they should listen to.
If this wasn't such a high profile case, would there be higher likelihood that she would be released because no one's paying attention? This one, a lot of people are paying.
Yeah, probably, because the court of public opinion weighs in on everything, doesn't it?
Yeah.
And there's lots of arguments that, we see the arguments, she's under a death threat inside the system, and, she's got a lot of haters on the outside. She still took a life to me, violently, wrongfully, and she needs to be held lifelong accountability for that. And, in rehabilitation, boy, that's a fun word, isn't it? Mm-hmm. She has good behavior in prison. Well, because she wasn't given an opportunity to kill anyone in prison either, was she?
Yeah.
I just, you rehab someone from drugs, you rehab someone from alcohol. There's two things I really wonder about rehab. First of all, sexual predators and child predators, they're never rehabbed. That is a broken toy. That is a broken brain going on right there. And someone that reaches the level, again, I'm not a licensed psychologist or a psychiatrist, but when you reach that level of violence and willing to do violence on others in your life and kill someone and take a life in that manner in which you did, I'm dubious about rehab.
It kind of feels like if you're capable of doing that, you're capable of doing that. And I think some people are, and some people aren't, or are only capable in like a life-threatening type situation. If you're just kind of doing it by choice and you're not being threatened, there's something that's not working right up there. And I don't know that that's a switch you can ever really flip back.
And the other thing too, a big reason why we put people in prison is for the individuals that committed the crime, but also for society at large, to show that there's really, really, really consequential actions for your bad actions. Mm-hmm. And so people don't have long memories. They're not. So here's a potential, again, thought experiment. So here's a potential person that's got a lot of rage towards someone, and they're thinking about murdering someone because of the actions that they took. They got their wound collectors, and so they're gonna act on this rage and vengeance. And now, one day they're thinking to myself, oh man, I'll be put away for my life. I don't want to spend my life in prison. But now they look at this case and say, oh, look, she got out after 30 years. They're not thinking the 30 years lost it. They're zeroing in on as a rationalization, but they got out. I could actually kill this person. And even if I don't get away with it, I can probably get away with it because they're that kind of narcissistic person. They're thinking to themselves, I could probably be paroled on it. If I make it look just right, I could be paroled on this. And so they're not thinking I've lost 30 years. They're saying I can be paroled because of this. I'm not liking it.
Yeah, I mean, it's a way that people will look at things going, is it worth it? Is it worth it to me? Is it worth the 20 years or the 10 years or whatever that they'd likely get if it was looked at as, not first degree murder, or it was manslaughter, or it was accident, whatever. Yeah, they'll look at it that way. I mean, a strange analogy I'll make here, and I was just kind of joking that I was walking into Kohl's, the department store, and there was a sign that said $50, no smoking in store, $50 fine. And I thought, well, if you have a lot of money and you're a real asshole, just walk around the store with 50s and just smoke away. Like, here's the fine, go away. And just, okay, I'll pay the fine. And it's that sort of thing where it's like, I'm good for it. Cool. I want to smoke right now.
Yeah.
It's like, if you're in that mindset and you're like, I'll do it because to me, it's worth it. Yeah.
Yeah. I'm not a liker of the, every time we cover a case where a parole comes up on someone who's actually a murderer, I cringe because I don't think it's to me, it always sends a bad message. It depends on the case. We have the Menendez brothers, which is a different kind of case there. But when you have, cold-blooded vengeance, from, in Selena's murder, someone needs to pay a longer price, I think. But again, let's see what the family says. Yeah, I think that's what matters.
That's what's going to happen next. The Texas Board of Pardons and Paroles initiated this review back in October, and it includes compiling the case file, the recommendation letter from El Salvador, an interview with her, and any letters submitted from Selena's family. So they're going to take a look at all that stuff and then make a decision on where this goes. I'm going to guess no, but I guess we'll see. I think that she probably has a better chance at life or a longer life behind bars than she does outside. Would be.
Yeah, you're used to it now. You've been there for 30 years. Why not keep it going?
And there's a bounty probably on her on the outside as well. I would imagine for something like that.
Yes.
So
that's our report for tonight. I'm Tony Bruschi. Thanks for joining us. Be sure to press subscribe wherever you get podcasts or videos so you don't miss any of our updates. Good night.